Can a lawyer be summoned by the police or ED just because he gave a legal opinion or represented a client? If this continues, the entire foundation of the legal independence could collapse. The Supreme Court has now stepped in. This is not just a legal issue, it's about the soul of our justice system. Hello, this is Dr. Arjun Chowdhury, advocate. Today, we are discussing a Suo Moto case that goes to the very heart of the legal profession. Can investigative agencies summon advocates for simply doing their job? Is legal advice now a basis for investigation? And where do we draw the line between legitimate inquiry and coercion? The Supreme Court has decided to take this issue head on. Let's explore what led to this moment, why it matters for every citizen, and how it affects the future of legal representation in this country. On June 25th, 2025, a division bench of Justice K.B. Vishwanathan and Justice N.K. Singh raised serious concerns when the Gujarat police issued summons to an advocate who was merely representing an accused person. The bench did not just stay the summon, it sounded an alarm. The bench remarked, this trend undermines the independence of the legal profession and the very fairness of our judicial system. Following this, the matter was referred to the Chief Justice of India, and on July 4th, the Supreme Court registered a Suo Moto case. A three-judge bench led by CJI B.R. Gavai with Justice K. Vinod Chandran and Justice N.V. Anjaria will hear the matter on July 14th. This is not just about one case in Gujarat, it's about disturbing pattern across agencies, especially the ED. Recently, two senior advocates, Arvind Datar and Pratap Venugopal, were issued summons by the Enforcement Directorate. Why? Simply because they gave legal advice to their clients in cases being investigated. The legal fraternity erupted in protest. Bar associations across the country called this out as intimidation, and the ED had to withdraw the summons. They even issued a circular stating no advocate shall be summoned without prior permission of the ED director. But let's ask, should that even be necessary? Isn't this common sense already rooted in the constitutional protections? Now let us understand what the law says. Article 19(1)(g) of the Constitution guarantees the right to practice any profession. Advocacy is a noble profession and not a business. Bar Council of India rules, especially Chapter 2 of Part 6, clearly states an advocate shall not be identified with the client's cause. He is not to be made liable for the acts of his client. Further, the Evidence Act, Section 126 to 129, protects confidentiality of the client communication, legal privilege in options, opinions, and strategies. So, if investigative agencies start summoning lawyers just for doing their job, it's not just unethical, it is unconstitutional. If we see the international position, we will find that in the United Kingdom, the legal professional privilege is sacrosanct. In the US, under the attorney-client privilege, even the courts tread carefully. In fact, in the famous Arjun versus United States, the US Supreme Court held that full and frank communication between lawyers and clients is essential to justice. India too has respected this principle until now. Now, imagine a future where a lawyer is scared to give a frank opinion. Legal strategy gets leaked due to fear of summons. Clients hesitate to be honest with their counsels. This is not just an attack on the advocates, it's an attack on access to justice. If lawyers are to be targeted for professional duties, the entire justice delivery system will collapse like a house of cards. We must remember what Justice Krishna Iyer once said, a lawyer is not a mouthpiece of the client, but a vital organ in the administration of justice. So what is the road ahead? The Supreme Court's Suo Moto action is a ray of hope. It signals that the judiciary will not tolerate this erosion of independence. Expected outcomes from the court may include clear guidelines on when or if ever advocates can be summoned, protection of legal privilege and opinion, directions to all agencies including the ED, CBI and the state police, Bar councils, law schools, and the entire legal fraternity must stay engaged with this issue. This is a defining moment. So, to all young lawyers, legal professionals, and law students, this is the case that will shape the boundaries of your practice. Let's uphold our constitutional values, defend the dignity of the bar, and ensure that legal advice remains sacred, not suspicious. That's all for now. This is Dr. Arjun Chowdhury, Advocate. Jai Hind.